Mr. Chairman, honorable members of the committee, my name is Mark Meckler. I'm president of Convention of States Action, and we appreciate that you've given us an additional 30 minutes. I don't intend to take all of that 30 minutes. I'll leave time for questions, plenty of time if you all have them. I don't want to repeat what I said at the last hearing. I think it was very clear. I think we've had clear testimony from both proponents and opponents of this resolution. On the desk in front of you, I brought materials for the committee which summarize my remarks in a much better way than I can do it. You've heard two primary things that I think are very important in opposition to this, the two what I would say are cogent things. Number one, you've heard that there is absolutely no law or history around the idea of calling an Article 5 convention. That is simply factually incorrect. In front of you is a green book. It is a treatise written on the subject of the law of Article 5. It is written by the single greatest scholar, according to everybody who studied the subject in the country on Article 5. It's Professor Rob Natelson. And Natelson has spent approximately the last 10 years studying the subject and has written the only existing treatise on the law of Article 5 that exists in the country. Many of the legal and technical arguments that I made before this committee last week are contained within that book. So if you're looking for deeper reading, if you're a lawyer, I will tell you it's fairly dry. If you're not a lawyer, it's going to be a great sleeping aid for you. But everything you would need to know about the law and history of Article 5 is contained in there. Also last week, when I addressed you, I had the opportunity to address the grave slander being perpetrated against the founders by the opponents of this. And they claim that the founders engaged in a runaway convention, exceeded their authority, abused the trust of the people of their states, and did something that they were not entitled to do. The second book in front of you, the maroon-colored book, is it is a review article from the Harvard Journal of Law and Business. It is written by Michael Ferris, one of the other leading researchers on Article 5. It is the definitive history of the 1787 convention, complete with hundreds of footnotes, and it clarifies exactly what happened at that convention. The convention itself was not a runaway, and that those men escaped unscathed with their honors intact, as we all know. So if you're interested in the history of the convention and the proof that that convention was not a runaway, then you have both of those documents in front of you. I think these are important documents for you because there are two fundamental questions that face the committee in regard to this particular measure. Number one is, was the original convention a runaway, proving thus that any convention would be a runaway? The answer is clearly and definitively no, according to that document. And the second is, do we know what happens in the convention process and at a convention? And I think the Green Book, the Law of Article 5, tells you definitively yes. I'd like to summarize the process and the safeguards for you, if I may. The Article 5 process was put into the Constitution by the framers of the Constitution. It was actually inserted September 15th, 1787, 2 days before the end of convention. Colonel George Mason stood at convention, the man who spoke more than anybody else at convention, one of Adams and Jefferson's and Madison's mentors, and addressed the convention. He said, "We have a terrible problem with the document that we've created. We've created a document that gives the power to Congress to propose amendments should they deem them necessary, but we have not given the power to the people acting through their states, through their state legislatures." And he asked a question, essentially, and I'm paraphrasing. I'm not near as eloquent as he was, nor any of the founders, but he asked the question, are we so naive that we believe that a federal government that becomes a tyranny will ever propose amendments to restrain its own tyranny? Now, I imagine that they laughed at the time. We, of course, don't have video, but I think it's pretty clear that they did laugh. Madison's notes are very clear, and they reflect something very simple in that moment. Two Latin abbreviated words, nin com, which stand for no comment. In other words, these men who debated and argued about absolutely everything that they were putting into this great document, the United States Constitution, debated nothing about the concept, about the idea that we, the people acting through the states, should have the power to propose amendments. And in fact, a vote was then taken. And this is one of the very few things, in fact, I believe the only thing, not debated and unanimously inserted into the United States Constitution. The vote was unanimous to give us this power. Specifically, and importantly, they gave you this power. I think this is an extraordinary thing, and I think it's an incredible responsibility. You are alone among anybody in the federal government of the United States of America that can actually call a convention, propose amendments, and then ratify those amendments. You were given that power because specifically the founders believed you were the best kind of government because you represent government close to the people. You respond to your constituents. Your constituents can come to this building and visit with you. I watch them do it every time I'm here. Same is not true for the federal government in Washington, D.C. So they were enamored with the idea of government close to the people because they actually were government close to the people. Most of the men in that convention had served in colonial legislatures, town councils, city councils. They understood governance close to the people. Did they believe that the people who served in those levels of government were better people than people who might serve in a centralized government? The answer is no. They understood human nature. And they understood that people were flawed, but they also understood the idea of accountability. You all go home to your districts and you meet with your constituents. You see them in the grocery store. You see them at soccer games and baseball games and at church. And that is the kind of government they trusted. So they gave you the power to call this convention. And that's what we're proposing that we do. And the process works like this. When 34 states pass the same resolution, 2/3 of states, the states will then commission their commissioners, as they're called officially. Some people refer to them as delegates. The framers referred to them as commissioners. You will empower and limit the power of your commissioners. And you have absolute control to do that. They serve as agents of the state. You appoint them as your agents, and they are only imbued with the authority that you give them. They will likely carry a physical commission with them or a digital commission that says what their authority is at convention. When they arrive at convention, they will gather in convention, they will elect their officers, and they will begin to deliberate in convention. Likely, and we know this from the history, you can see in the law of Article 5, they will break into committees. Those committees will likely be broken along the lines of the 3 subject matter areas as proposed in this resolution: fiscal restraints, term limits on federal officials, and scope and jurisdictional restraints on the federal government. They will debate proposed amendments. Many of the states will bring amendment packages with them. I know Texas has already been working on an amendment package. We have Virginia to thank for bringing the Virginia plan to the original convention in 1787. They will then come back together after debating committee, and those amendments, those proposed amendments, will be debated on the floor of the convention in front of the committee of the whole, or the entire floor of the body of the convention. And when 26 states, a simple majority, agree on an amendment or a group of amendments, those amendments will then be sent out to the states for debate and ratification. Congress decides whether the ratification process will be by state convention or it will be by legislative ratification. In the history of the country, we have 27 amendments. 26 have been ratified by state legislatures, 1, the repeal of prohibition, by state ratifying conventions. In the event, unlikely event, Congress were to choose state ratifying conventions, the state legislature would itself define what a state ratifying convention is. It takes 38 states to ratify anything that is proposed by a convention of states. And this is a very critical point. People say the convention is such a scary place. Who knows what the convention can do? And the answer is nothing. The convention has no power. The convention may not amend the Constitution, change the Constitution. All the convention can do is make suggestions. There's literally a meeting for making suggestions. And so when those suggestions go out, it's going to be up to you here in the state legislatures to decide what gets ratified. And I think this is one of the greatest points of genius of the founders in this process. It takes 38 states, 3/4 of states to ratify. There is, by the way, in all of the American system of governance, no bar that is higher. There is nothing else in the American system of governance that requires 3/4 of the states to approve in order to do something. You know in your own legislature how hard it is to get to a majority, 2/3 being almost impossible, 3/4 being a bar so high, it's almost hard to imagine it happening. What that means for me, and I think this is really important, is that in order for something to come out of convention and be ratified by 38 states, it must be something that the vast majority of Americans are in support of. Things like term limits, which are supported by roughly 85% of the American public. Things like balancing the budget, forcing the federal government to live within its means, supported by roughly 83% of the American public over long-term polling. And today, 72% of the American public, again, across the aisle, says that the federal government is too big and does too much. Now, we might argue about what needs to be cut and which programs are too big and do too much, but the American people know full well, and their sentiment is resoundingly in this direction, that the federal government is out of control. And so what we're asking you to do is to follow the process laid out by the founders. They told us that this day would come. They told us that a time would come when the central government had outgrown the box of the Constitution that they themselves drafted, and they put in a provision to allow you to fix it. This is nonpartisan. This is not about a particular party, and it's not even about a particular policy. There is a fight being had in America that I would argue is the most fundamental fight being had in American politics today, and yet it's not talked about by the politicians in Washington, D.C. It's not about whether we have public health care or private health care. It's not about the level of taxation or regulation. The fundamental fight we are having as Americans is about who decides. The question that we have to ask ourselves here in South Carolina and all across the country is, do we believe that South Carolinians should decide for themselves, or that Washington, D.C. should decide for us? The Convention of States project comes down on the side that people here in South Carolina should decide for themselves. They trust you. They elected you. They believe in you. And I hope that you will act on their behalf. The over 33,000 citizens of South Carolina that have signed the petition and asked you to join the 15 other states, most of your sister states in the region, that have called for a convention of states. And Mr. Chairman, with that, I'll close, and I'm happy to take questions.
Yes, sir. I do have a few questions, and this is kind of a compilation of what you've just told us and what we've heard previously also. Okay, so looking at Article 5, so two-thirds make the call, so that's 34 states. 34 states. Okay, 34 states. And we had some discussion previously about the language, because, you know, before us we have either, you can say they're parallel or competing bills. We've got the balanced budget, and then we've got the broader convention call. How many states have passed one or the other? And if you could tell me one, you know, which one?
Sure.
What states have passed what now?
The Convention of States resolution, the one that is before you today, that I'm discussing, that's supported by the Convention of States project, has been passed in 15 states.
Okay.
Just night before last, the Wisconsin House passed it as well. So we've passed it many more in one house or the other. But 15 states have passed this resolution in total. In those states, the operative language is the same. In other words, there are three things that are discussed: fiscal restraints, term limits on federal officials, and scope and jurisdictional restraints. That's at the very beginning, after the preamble. So that's the Convention of States resolution. The balanced budget amendment has been in process and trying to collect applications now for roughly 40 years. There's some argument about aggregation on the balanced budget amendment. By aggregation, I mean, is the language the same? And can they actually be compiled towards the 34 states? And there is dispute among scholars on this. The highest number that I've heard is 27. I think it goes down as low as 15, depending on which scholar you talk to in regard to aggregation. There will be federal litigation around whether they can aggregate. So I think there's somewhere, I would say, between 15 and 27 on the balanced budget amendment alone.
Okay, and then my next question kind of pigtails to what we had talked last time. Okay, I'm looking at the sections, and I'm particularly looking at 3125. I used to call this in court the pre-ramble, not preamble, pre-ramble. You know,
Yes,
and you know, we hold these truths to be
Yes,
self-evident. And I'm looking at Section 1A, the General Assembly finds, and there are a number of things that quite candidly would bring us to the table, the debt, things of that nature. None of that is required to move forward from a variation from another state. And here's where I'm heading this. If you see we have a diverse committee.
Yes, sir.
I think each in our own way, we recognize there are issues wrong, as each in their own way speakers for both sides did. Sometimes rolling out the, not necessarily divisive language, but you may feel it's important for one reason, I may feel it's important for another. So is there anything detrimental to the language if we remove that Section A, for example?
No, sir, and I would say you may remove it or alter it as you see fit. I actually think that's important, and that's been done in other states. Well, that is an expression of the intent and the feeling of the legislature considering the measure, and I think it's fine to either remove it or to edit it as you see fit.
Well, in sad commentary to the legislative process, and you noted this somewhat, I'm going to get down to Section 3, which is the same section. I think I said the other week, sometimes we major in the minors.
Yes, sir.
And so, yeah, we could alter it, and then we'd have 6 months debate on which things we hold to be self-evident. So I was curious, and again, we hadn't had this discussion on the committee, but if that was not there, that's
Not a
fatal.
problem.
I would assume in looking at it, the sections that really need to match are the B, C, and then Section 2 components. Is that a fair
Correct.
statement?
Yes.
Because, and this leads me to Section 3. When we spoke I think it was last week, I'm losing track.
Yes, sir,
of
it
weeks.
was.
The mechanics, and it just kind of caught my eye. There was, set out for whatever reason, like that, the House would pick 3 and the Senate would pick 2 or whatever. Again, there's a lot of good bills that are on one body or the other that get hung up on, why did you get 3 and I get 2? If we altered that, changed that, 'cause clearly that you've got to have the marching orders that are included in there. Is that really fatal to the bill in any way? If the House chooses, and the House and Senate get together and choose that basically even after the fact, the determination, is that a problem?
It's not a problem. In fact, personally, my preference is that those are separated. I think it does require a lot more deliberation, as you say, essentially the devil's in the details, and there should be a lot of debate around that. And so, no, it does not prevent aggregation if you were to remove that and discuss that later.
Okay. Thank you. And so that Section 3 takes us really, and just for members, I was just looking, that Section 3 takes you to the end of the document.
Yes, sir.
And it is delineating all the things on the way that we would select and things of that nature. And as I look up and down the row, I see each member that has some bill that's in the Senate that we can't seem to get any movement on. So I think the smoother, if we choose to go forward, we could do that. Those were the questions I had in looking at 3125. You might have stated this before, but again, for the committee, we've seen the discussions have mostly focused on 3125, just by nature of kind of the evolution of who attended and what we discussed. My personal view is I feel like the language in 3125 somewhat covers the balanced budget issue, even though it doesn't say it straight out. Is there any pro or con that you see of moving forward? If we were to move forward, I just feel like doing 2 can almost be a distraction. And I
Yes,
know
sir.
you're here to advocate one in particular, but I mean, is if we did pass the balanced budget, is it somehow fatal to what you're doing as long as the other one's moving, or is there a pro?
I don't think it's fatal. There's two ways I'd like to address that, if I might. One is your constituents. Today in the state of South Carolina, as I said, over 33,000 people have spoken out in favor of the Convention of States resolution. You've seen not near that many, thank goodness, but many come to committee and appear and drive across the state to be here and debate it and discuss it. The same is not true for the balanced budget amendment. And the reason for that is, while I'm generally in favor of a balanced budget amendment, as are our people, most of us believe that it won't solve the problems that ail the nation. And there is a fundamental problem for states with the balanced budget amendment alone that I think is a problem, which is without structural reforms limiting the scope and the power and the jurisdiction of the federal government, what they will do is find a way to simply cram programs down the state's throat. On average, I don't know exactly what it is here in South Carolina, but on average, a state budget is about 60 to 65% controlled by the federal government today. And it is my opinion that we don't want to do anything to empower or incentivize them to control more of what you do. We're looking to empower and free the states to act as laboratories of democracy, and I think a balanced budget amendment alone does that. So both, in my opinion, the prudence of the approach requires the 3 subject matter areas. Ours, by the way, would include discussion of a BBA fully, and so you get essentially the 2 for 1, and your constituents are in support of the Convention of States resolution and not a BBA alone.
I've noticed in some of the previous testimony that the other side also pointed out that there, could be a fear in a pure balanced budget amendment that you're almost codifying activity that we don't believe may be constitutional to start with. And I heard that in several of the folks that testified. So it seems like imposing physical restraints gives some opportunities that may not be there if you were boxed into.
I think that's correct.
Members, anyone else have any questions? Yes, sir.
Thanks, sir. One quick question. We've gone through a few hours of this, and I hope I'm not being repetitive. I may have asked you this last time.
All good.
I've somehow lost my notepad from the last meeting. When we talk about aggregation, some of my readings have indicated, and of course, ultimately there is an unknown. Would you agree there is some unknown element?
We
as
certainly
far as how
don't.
these
We do
would
not
be-
know exactly what amendments will be proposed. The convention itself is a deliberative body like a legislature, so we do not know exactly what amendments will be proposed. I think that's fair enough.
Well, couldn't the language of the legislation restrict it to what amendments would be proposed? Isn't that the whole point?
Well, it restricts it to subject matter. So the restrictions are in place and we know what subjects may be discussed, but as far as an exact amendment, that is not contained within the resolution.
When Congress proposes amendments to the Constitution, they give the exact wording of the amendment, do they not?
They do in the exact same way that a convention does. In other words, Congress every day, potentially, is a sitting convention. And before an amendment comes out of Congress, it is debated and deliberated and amended and drafted and redrafted in the same way as would happen in a convention. So it's, it does not come out of thin air, obviously. There are subcommittees and committees and debates among members long before it comes out of Congress. So the process is virtually identical.
That's exactly what I'm thinking. They're two equal powers. Is that fair to say?
I think
Or
that's fair to say.
Equal methods.
Yes, that is correct.
Back to my aggregation question. Is it fair to say that two proposals could be combined if they were not identical? The more restrictive would survive as opposed to the less restrictive? Or do you have an opinion?
For purposes of aggregation, that's not the history, unfortunately. There have been over 400 applications for a convention in the history of the country. By the aggregation method you propose, we might have been in convention already. But what it seems to require, based on history and precedent, which is what the courts who've all weighed in say Article 5 is governed by history and precedent, is that they have to be virtually identical.
Is there precedent on that?
The courts have weighed in, and you can find these cases in the book, in the Law of Article 5 book. The courts have weighed in and have specifically said, not to the specific question you're asking about more restrictive versus less restrictive, but the courts have repeatedly said, and there have been, I believe, over 40 cases, that the law and history and precedent of Article 5 control.
And to that point, I mean, there are lots of great law review articles, but law review articles are not wearing black robes.
Absolutely,
At the end
that
of
is
the day.
correct.
Thank you.
Thank
Appreciate
you.
it.
Mr. Elliott's recognized.
Thank you, Mr. Chairman. Mr. Meckler, thinking about the process subsequent to whatever comes out of a convention and for the ratification, and then the issue of the Congress deciding is it going to be by state legislature or state convention. And you stated that's only happened, ratifying convention has only happened one time, and that was with the repeal of prohibition. Is that correct?
That's correct.
Okay. In that method, the ratification method as determined by Congress applies equally to amendments proposed by the Congress or by an Article 5 convention, correct?
That is correct as well.
Okay. When the Congress determines that, how is that by a majority vote of each House and Senate?
Yes, that's correct.
And does the president have a?
The president has no role.
Okay. Thank you.
Calhoun's recognized.
Good afternoon. My question is not so much about the law, but as it is to how long, if we have all these amendments coming, the subcommittees are meeting, the committees are meeting, what time frame are we talking about that's going to run, I guess, simultaneous with our Congress? I mean, are we looking at 2 years, a year?
Yeah,
I
let
mean,
me
what
make
is
sure
the
I
Convention of States, how long would that last?
I just want to make sure I understood the question. You're asking the question of the tenure of a convention of states once they gather. The answer is we don't know, and they can gather as long as they choose to gather. I will venture a guess for you and honestly tell you it's nothing but an educated guess. likely the vast majority of individuals serving as commissioners for the convention, if history is any guide, and we have over 40 interstate conventions, likely the majority of commissioners will be sitting or retired state legislators. Legislators on average have sessions. They're used to session times that run anywhere from 90 to 180 days. We have some aberrations. Obviously, there's some states that run year-round, but the majority are 90 to 180 days. My expectation is that you would see a convention that ran somewhere between 90 and 180 days. But again, I'm being perfectly honest, that's just a guess because we've never had a convention of states.
Just to go a little bit further, I mean, we're talking about three aspects. We're talking about term limits, and it's not spelled out as to the length of the term limit that's going to be considered, which is going to have significant amendments and arguments. You've got the limiting the power. And I mean, currently the Constitution sets out 4 areas, but we've expanded that so significantly that any amendment could come off of that. Is there a provision to carry the convention over to the next year outside of it 180 days?
Again, the convention will convene and adjourn at its own discretion. And so there is no, the convention could, at its own discretion, adjourn temporarily and reconvene. There's nothing that would prevent that.
And I guess getting to the funding, just for information, all right, we're talking about a group of members coming from South Carolina with subsistence, hotel, all of this going along. We've got expenditures of all of that to take place. Ballparking it, have any idea what this convention of states would cost?
You know, I think the members of the legislature would have a better idea of that. Y'all send people to conventions and meetings around the country on a regular basis. So no, I can't really say each state would bear its portion, but I can't say what that would cost because it's also up to you how many delegates you send. As a state, you could send a single delegate, you could send an entire delegation. So the cost will vary depending on how the state chooses to approach a convention of states.
That's going to be some of that federal money they're going to give us. Mr. Elliott,
Mr. Jones, but this follows up. This follows up on this line of questioning, and we haven't touched on this. I'm assuming the states would bear the cost for the convention, not the federal government.
That's correct.
Because I heard they're going to be broke in 4 years anyway, so they're coming up. Mr. Jones, Rector.
Thank you, and thank you for being here, Mr. Meckler. Do you believe that the states currently have the ability to rein in the federal government and to balance the federal budget?
By calling a convention of states, yes, I believe they have that power.
Okay. And outside of an Article 5 call for a convention, do you believe that we currently have the ability to do some of these things?
When you say some of these things, I certainly think there are things that states can do. Do I believe that the states currently possess the power to rein in the federal government to the extent expected by the founders in 1787 or through ratification in 1789? No, I do not.
Gotcha. And just to kind of, I believe this is a issue of courage. You know what I'm saying? I think we've got the ability currently in the states, but we don't have the courage to stand up and just as examples, we've talked about term limits and things we can do to essentially interpose in federal usurpations and things like that. One thing I want to ask you to, what are your thoughts on the fact that George Mason didn't sign the Constitution?
I think he was correct, is my honest opinion. You know, I had an extraordinary experience. Mason's actual copy of the Constitution that he worked on in the convention resides at Williams College in upstate New York, and my nephew graduated from there last year, and I had a chance to be in a room with that document. It was incredible. You can read his reasons for not signing the Constitution. So he was essentially what we would call at the time an anti-federalist. And I think if you look at history and the way history has panned out, and you read both the Federalist Papers and the Anti-Federalist Papers, for the most part, the Anti-Federalist arguments seem to have proven to be more correct in hindsight.
Right. And I consider myself an anti-federalist. Also, Henry and Mason and Jefferson, you know, what they fought for. what I find interesting, I mean, Mason even fought against ratifying the Constitution for Virginia. You know what I'm saying? Because he believed that that it was too much centralized power.
Correct.
You know, and part of my concern, I mean, with Article 5, you know, is the uncertainties of the rules not being clearly stated in the Constitution, you know, of how that would actually go down. So
I'd like to address that.
Yes,
if I might.
yes, sir. Yeah.
This is a common misconception, in my opinion, that people have about Article 5 and about the Constitution generally. And they say that Article 5 doesn't contain the rules about how an Article 5 or an interstate convention would work. That's because our Constitution was not drafted to contain those sorts of rules. And I often ask this question, I've asked it all over the country, how do we know what due process is? Due process is not thoroughly defined in the United States Constitution. And the reason that we know what due process is that most, if not all of us here in this room would describe ourselves as originalists or textualists. We look back to the document as drafted in context. We want to know what the men who drafted it and ratified it were thinking. And we know that they knew exactly how interstate conventions worked because the vast majority of the men in the room in 1787, they had participated in interstate conventions. There were 11 interstate conventions previous to 1787, just in the 2 years prior. Most of them had been in those conventions. So for them to have put the rules for convention, and by the way, all the conventions, and you can read about this in the law of Article 5, operated according to basically the same instructions and the same rule set. And so for them to have put that in the Constitution would kind of be like defining air. They all understood, just like they all understood what due process meant and why there isn't a thorough definition of due process in the Constitution. Yet we all of us who consider ourselves originalists, we understand what due process means, and we know it because of the history. We know the same thing about Article 5, and the fear and the idea that we don't know it just means that we haven't looked at the history. By the way, there have also been 30 plus interstate conventions since 1787, all operating on virtually the same rule set, all documented in the law of Article 5 there for you.
Gotcha. And I mean, just to kind of continue that thought, we were talking about the Anti-federalist. I really appreciate the fact that Mason didn't sign the Constitution. And I know that sounds wild, but the fact that because due process, our Bill of Rights, that I know that was a major reason for why he didn't do that.
Correct.
And so I appreciate that. Term limits. Okay, I know term limits, and I am a co-sponsor. I'm happy to be a co-sponsor of our term limits bill in South Carolina. I think in a lot of ways we've got to apply these things to ourselves before we can apply them to the federal government, if that makes sense. But what are your thoughts on term limits? I mean, because I know it's not even all of these remedies I don't think are a silver bullet. I think
Correct.
At the end of the day with term limits, or we talk about reining in the federal government and all these things, it's going to come back to us saying, okay, how are we going to do this? How are we going to, so what are some ideas, I guess, on when that comes back to the states? What can the states cut and change in order to rein in the federal government?
So there's a couple of questions in there, so if I can take them sequentially, I would appreciate that. So first, your question was, what's my personal feeling about term limits? And there are a couple of ways for me to slice this. Most importantly, I want to say that my job and my personal approach to politics in the broad American sense is I have a lot of faith in the American people. And the founders had a lot of faith in the American people. I'm often surprised and insulted when people say there are no people like the founders around anymore. And I'm not saying this to blow smoke at y'all, but I've been in a lot of state legislatures across this country, a lot of people serving in state legislatures that I'd put up there with the founders any day. And so I have faith in the American people just like the founders did. And 85% of the American people want term limits on Congress. And what that means to me is that if we're not tyrants, then we should have that discussion. And we should give them that right to have that discussion in a meaningful way where they have the possibility of imposing term limits. Now, so that's my feeling generally. I'm going to tell you my personal feeling about term limits because it's a little bit different than that. Kind of on the edge. I kind of have mixed feelings about term limits, and here's why. When you limit the terms of elected officials alone, you cause them to rotate through office, and you do not disempower the bureaucracy and the lobby class and the staffers And those become the institution, rather than the people who are elected and accountable. So I worry about that. That's why if you read the language of our resolution carefully, it calls for the discussion of term limits for federal officials. So more broadly, that includes not only Congress, but I think importantly, staffers and bureaucrats as well. The founders never intended for somebody to go away to the capital city and be there for 30 or 40 years. And so I think when you package those things together, I'm generally then maybe in favor of term limits. But what I'm mostly in favor of is giving the American people the right to have that discussion in a meaningful way. I think your second question, and hopefully I'm repeating it to you clearly, was, what are the states actually going to propose? Like you were saying, how can the states actually limit the federal government? And I'll give you a couple of what I think are important examples. When we talk about limiting the scope, power, and jurisdiction of the federal government, I think one of the most important ways is to return the power over education to the states. I travel all across the country. I talk to people on both sides of the aisle, and people are frustrated because the states send money to the federal government. They skim a bunch off the top. They have a huge education bureaucracy with now over 5,000 people in it, spending hundreds of billions of dollars. And over the time that we've had the Department of Education, our test scores have increased exactly 0. And so I'm a big believer in returning the power of education to the states. Now, I would argue that the federal government having usurped that power is just straight up unconstitutional. I would quote Jefferson in saying that. Jefferson, the greatest promoter of public education in the early era of the country, when asked by William Henry Lee about the idea of getting federal money for the University of Virginia, said, "I can't do that because the federal government has no right to be involved in education. It's unconstitutional. It would require a constitutional amendment." Obviously, we don't have the Education Amendment today, but they have usurped that power. And so one way to restrain that is to specifically prohibit the federal government from being directly involved in our educational system. So that would be an example of something that the states could do to reclaim their power.
That's great. And yeah, all of these things, I think they come back. I mean, it's going to come back. It's going to come back to foreign policy and the state's involvement in militarily. I'm just going to give you some examples. I've got a bill to defend our guard. We've spent, $6 trillion in the Middle East. We're spending $4 billion a month in Afghanistan. We built the biggest embassy in the world in Baghdad,
Right.
$1 billion.
Right.
And you look at this and you think, okay, what can states do? So I think if we can intervene in situations like that and take gold and silver, if we can implement sound money policies from the state levels, regardless if it happens via an Article 5 convention or if the states realize that they can do it now, which I do believe the states can do it now. I think it's just a matter of us having the courage to stand up and tell the federal government no, which is inevitably what's going to happen. We're going to have to make the cuts. Last year, I want to say $9 billion of our state budget was federal funds, and I realize there's some discussion there about keeping those funds because some of those funds are leaving the state and coming back, so keeping those funds in the state is part of the solution, I think. But ultimately, all these programs and everything that's already not authorized, in our Constitution is what we're going to have to do regardless. So, but thank you very much. Thank you.
My pleasure.
Ms. Hennigan's recognized.
Thank you, sir. I just have one question. Do you really believe that amending our Constitution will suddenly cause lawmakers to start adhering to the Constitution?
No, ma'am. I do not believe that if they were not adhering to the Constitution right now. The reality is, and I didn't bring this prop with me today, the reality is, and you probably saw this last time, they are adhering to the Constitution. The question is which Constitution, and this is a very important distinction. Everybody should understand this very clearly. I said last time that I have a taste for reality. This is the Constitution that our federal government is following right now. This particular version was printed in 2012. It's 2,738 pages long. With the current updates, it's now over 3,000 pages. It weighs over 10 pounds. It contains every case ever issued by the Supreme Court telling us what that Constitution that you and I know and love says and means. I'm not aware of any human being that's ever read this entire document, not even any lawyers that I'm aware of. But this document gives them all the power that they use today. This one, the one that says right here on its spine, Constitution of the United States of America. Not that little one, not the one that our framers gave us, but this one. And the method that the founders gave us for getting from this back to something closer to that original one plus the Bill of Rights is Article 5. So I think I would say they are following today the United States Constitution as interpreted by the U.S. Supreme Court. And it's important we remember the distinction between those two documents. One last thing, historically speaking, is that the United States government, including the courts and Congress and the president, have proven particularly fond of following amendments to the United States Constitution. And there's a reason for that. It's not magic. It's not pixie dust. It's an incredibly muscular political activity to amend the United States Constitution. To be fair, politicians in Washington, D.C., not always the stiffest of spine. But when 3/4 of states, remember, so that's 3/4 of the representatives of the population of the United States of America say, we want this and we want our government to behave this way, the federal government tends to. And you can look back at the history of the amendments. They tend to follow them pretty strictly for at least 100 years. I think over time, government drifts, human beings have human nature and we drift. But we have a long history of the federal government paying close attention to and following amendments. Thank you.
Sir, we appreciate your time.
Thank you,
very
Mr.
much.
Chairman. Go to conventionofstates.com, press the button, sign the petition. More importantly, get 10 of your friends to do the same. When you sign the petition, then that sends a letter to your state legislator. You go on the list in their district as a supporter. We deliver those lists to the state legislators. It means something to them.